We do know that his return to Australia was really to take the manslaughter plea deal instead of actually facing the evidence before a jury and facing the charge of murder.
That was Tommy Thomas, and the man he's talking about is Gabe Watson, his former son-in-law, also known as the Honeymoon Killer. Gabe is back on U.S. soil tonight and charged with murdering his wife, Tina, 7 years after she died during an Australian scuba diving trip. Now, Gabe pled guilty to involuntary manslaughter charges in Australia and served an 18-month sentence. And just this week, he was deported home and arrested once again as he stepped off his plane in Los Angeles. Now, back with me is defense attorney Keith Sullivan, former prosecutor Tom Kniff also joins us. This is a case that we've been talking about since it first began, and whether or not charges were going to be brought, how was Australia going to handle it. Then we've seen, of course, that he ended up pleading guilty to an involuntary manslaughter. What was the basis of that charge and that plea? The
basis of the manslaughter plea in Australia was simply failure to render aid to a fellow dive buddy. That's all. It's not an intentional act. It's certainly not even reckless. The judge said at best there was no ill will, there was no maliciousness. At best it was stupid on his part, and that's all.
Yeah, and he originally got 12 months, and then they added on another 6 months because of the outrage.
Because the family was so outraged, and they did what families should do, is they petitioned, they became their best voice, and they tacked on another 6 months. Doesn't.
But Kimberly, it's a little more than that. Australian law derives from English common law, the same legal system that we follow here in the United States. In order to have a legally sufficient plea for even involuntary manslaughter, you have to show an utter disregard for human life. Basically, what this guy did was he voluntarily was extradited to Australia, and he entered a plea to involuntary manslaughter. As part of that plea allocution, which would have been under oath, which would have had a stenographer present, which would have been sworn, he went in there and he admitted that he basically, with an utter disregard for human life, stood by and watched as the life was choked out of his wife on this scuba trip.
Yeah, from lack of air.
When prosecutors in Alabama, if they get past these jurisdictional issues, which are serious.
But I think they will. You're talking about double jeopardy and whether it applies, because he pled guilty to the same crime essentially in Australia, but we've talked about
separate sovereigns.
Right.
Separate sovereigns. But they're going to be able to introduce, not on cross-examination, but on their case in chief, this prior sworn testimony under oath, where this individual gets up there before a judge, raises his hand, and
swears
that
it's admissible.
It's certainly admissible, and it's going to paint an image of him as a cold-blooded husband who was capable of sitting there and watching his wife die and do absolutely nothing.
Well, and I think they're going to take it a step further, of course, in Alabama, because they believe that he premeditated and that he intentionally killed his wife. They're developing some evidence that, in fact, there was a financial motivation for a modest insurance policy, that he intended to go to Australia on the honeymoon, murder his wife, and there's some eyewitness testimony from people, expert divers, that saw what happened when she was sinking, that he, in fact, turned her air supply off.
Kim, with all due respect, the theory is absolutely ludicrous by Alabama. It's just ludicrous. Why would he spend all this money to get married, spend money to go on a honeymoon, to go over there and turn off her oxygen tank?
Because he's a killer and an evil guy who's already remarried someone else. Mark my words, Alabama's going to put this guy away for life.
More importantly, the due process clause of the United States Constitution, right out of the Fifth Amendment, states that if you have evidence of a crime and you know the perpetrator of that crime, you must bring those charges forthwith. Here, they waited 7 years, and the defendant only needs to show that he's prejudiced by not having brought the charges.
There's no statute of limitations for murder, and they're going to say that they were investigating this crime, gathering evidence, and that's why they waited to bring these charges.
Due process clause has
We'll see, gentlemen, see how it plays out. Tom and Keith, thanks so much. Coming up.